Ladies and gentlemen of the jury, in giving you the law in this case, the court wishes to make it clear at the outset that the court will not discuss the facts because that is the principal function of the jury. The court will simply give you the principles of law which apply to criminal cases in general. I will then discuss with you the various elements of the specific crime which is charged in this particular indictment. The function of the court is to conduct the trial in an orderly manner, to rule upon questions of law arising in the course of the trial, and to instruct you as to the law which is applicable to the case. It is the duty of the jury to accept the law as the court states it to you, and the jury should consider and must consider all the instructions as a whole. The function of the jury is to determine the facts. You are the sole and exclusive judges of the facts. You must determine the facts solely from a fair consideration of the evidence. It is your duty and responsibility to determine what the verdict shall be. It is your own recollection of the evidence that will control during your deliberations in the jury room. The statements of counsel are not evidence. They are intended only to assist you in understanding the evidence and the contentions of counsel. The indictment itself, which you will take into the jury room with you if you so desire, is not evidence. It is merely the formal manner of accusing a person of crime in order to bring him to trial. You must not consider the indictment as any evidence of the guilt of a defendant, or draw any inference or guilt because he has been indicted. In this case, as you are aware, members of the jury, there are the defendants. In giving you these instructions, I will refer mainly to the defendant, because what I say applies to each defendant in this case. In all criminal cases, there are certain important rules that you must bear in mind. Among those is that which we call the presumption of innocence, the burden of proof, and reasonable doubt. In every criminal case, the law presumes the defendant to be innocent of the crime charged. The law permits nothing but legal evidence presented before the jury to be considered in support of any charge against the defendant. The presumption of innocence alone is sufficient to acquit a defendant unless you are satisfied beyond a reasonable doubt of the defendant's guilt based upon all the evidence introduced in the case. A reasonable doubt may arise not only from the evidence introduced but also from a lack of evidence, since the burden is always upon the Commonwealth to prove the defendant guilty beyond a reasonable doubt of every essential element of the crime charged. There are the types of evidence from which you may ascertain the truth as to the facts in any given case. One type of direct evidence, and the other kind is circumstantial evidence. Direct evidence is the testimony of one who states he has actual knowledge of a fact or facts, such as an eyewitness. Circumstantial evidence is the proof taken from a chain of facts and circumstances which clearly indicate the guilt or innocence of a defendant. The law makes no distinction between the weight to be given to either type of evidence. You should weigh all the evidence in the case. After weighing all the evidence, if you are not convinced of the guilt of the defendant beyond a reasonable doubt, you must find them not guilty. You, as jurors, are the sole judges of the credibility of the witnesses. In other words, you alone are to determine whether to believe any witness. If there is any conflict in the testimony, it is your function to resolve that conflict and to determine just where the truth lies. You should give the testimony of each witness such weight as, in your judgment, it is fairly entitled to receive. Now, the weight of the evidence is not necessarily determined by the number of witnesses testifying on either side. You should consider all of the facts and circumstances and evidence to determine which witnesses are worthy of belief. Both of the defendants have taken the stand as witnesses in their own behalf. With reference to such testimony, the court instructs the jury that the defendants have a right to become witnesses in their own behalf. Their testimony should not be disbelieved merely because these witnesses are also the defendants. In weighing their testimony, however, you may consider the fact that the defendants have a real interest in the outcome of the trial. You should give their testimony as much weight in your judgment as it is entitled to receive. As the court indicated to you earlier in this charge, there are two defendants on trial. Each defendant is entitled to have his guilt or innocence as to the crime charged determined from his own conduct and from the evidence which applies to him as if he were being tried alone. You may find any one or more of the defendants guilty at any time during your deliberations. You may return your verdict of guilty or not guilty with respect to either defendant. In the offense of robbery with which these defendants are jointly charged in the indictment, the Commonwealth must prove beyond a reasonable doubt